Elizabeth Siders' 16 children are in foster care as she and her family face charges related to allegations of abuse and neglect. Was Elizabeth forced to get married? We're looking at forced marriages and the push to end child marriage in Ohio.
I'm not voting on it. Is that okay? No!
Case file: 16 counts of child endangering. For defendants, one address in rural Ohio, and a birth certificate dated 2008 that, on paper, should never have existed. Picture a single sheet of paper, a marriage license issued in a West Virginia county courthouse, stamped and filed the same spring a 15-year-old girl should have been sitting in a freshman English class. That license is the visual anchor for everything that follows tonight, because it's the moment a legal loophole between two states quietly became the origin point of a house that would, 17 years later, empty out 16 children into foster care.
Elizabeth Siders was 15 when she got married. She was just a kid, but she was a kid who was pregnant with her first child back in 2008 when she and Gary Siders Jr., her current husband, traveled from Ohio to Mason County, West Virginia, to get married. Gary and Elizabeth were married on March 31st, 2008. Elizabeth gave birth to a baby girl 2 months later, and 17 more children followed. I've told you many times that Elizabeth has been pregnant nearly every year since 2008. Gary and Elizabeth went to West Virginia to get married because legally, Elizabeth could not get married in Ohio at the age of 15. Gary was 18. It was illegal for her to get married in Ohio, but in West Virginia in 2008, Elizabeth could get married at 15 if her parents allowed it. Right now in Ohio, a 17-year-old girl can get married if a parent signs off on it and a court approves. There are a number of hoops that a child has to jump through to get hitched in the Buckeye State at age 17.
If you're new here, this is the Hidden Case Files, and we build every story from what's actually on the record: court filings, legislative testimony, official statements, not speculation. So if that's the kind of true crime you want, go ahead and subscribe, because tonight's case is one of those rare ones where the paperwork itself tells you almost everything. Here's the scene investigators walked into. A rural property in Vinton County, Ohio. 16 children, ranging widely in age, living in what the county prosecutor has publicly described as conditions serious enough to warrant immediate removal. For adults now facing charges, the children's parents, and the paternal grandparents who lived alongside them. All four have been charged with felony child endangering, 16 counts apiece, one for every child in that house. And all four have entered the same plea: not guilty.
Able to get out of it finally. But back to Elizabeth and Gary Siders. Gary was 18, as I mentioned, when they got married in West Virginia. Elizabeth was 15. They're both in the Southeast Ohio Regional Jail, charged with 16 counts of child endangering. Gary's parents, Christina Lynn Siders and Gary Siders Sr., face the same exact charges. They've all pleaded not guilty to all of the charges. And the investigation into what was going on in the house on Omer Street, where 16 children were rescued, is well underway. There are so many questions.
That's the crime scene. Now here's the detail that turns this from a single tragic household into something with much deeper roots. Because according to public reporting, the mother in this case was not always an adult in that home. She was, at one point, a child inside a very similar arrangement herself. She was 15 years old in the spring of 2008 when she traveled across a state line to marry a man 3 years older than her. Ohio law wouldn't allow that marriage inside its own borders. She was underage, no path around it. But drive far enough west, into a neighboring county in West Virginia. And in 2008, the law there permitted a 15-year-old to marry with parental sign-off. So that's what happened. A short drive, a signature, and a license that made a legally impossible marriage in one state perfectly legal one county over. Ask yourself this: what does it mean when the difference between this cannot happen and this is fully legal is a 20-minute drive? 2 months after that wedding, she gave birth to her first child. 17 more would follow in the years after. One set of twins among them did not survive. By the time investigators arrived at that Vinton County property, she had spent essentially her entire adult life, which had started before she was legally an adult at all, inside a single continuous cycle of pregnancy, childbirth, and, according to the allegations now before the court, isolation. That's the moral center of tonight's case. And it's worth stating plainly, because we're going to come back to it 3 times before we're done. A 15-year-old cannot consent to becoming somebody's wife.
Why were the children not sent to school? Why were they being hidden, as the county prosecutor has said? And why was Elizabeth marrying at 15 and then giving birth to children one after the other when she should have been in high school and going to prom? Was Elizabeth being abused? Elizabeth appears to have a bruise on her arm in the intake video. We don't know how she got that bruise. Was she a victim and didn't even know it? Her brother has said on Facebook that Elizabeth was indoctrinated into the Siders family. But what exactly does that mean? And had West Virginia not allowed Elizabeth Siders to marry at age 15, would this child endangering case be unfolding today? Back in 2023, West Virginia changed the state's law on marriage. Prior to that, 16 and 17-year-olds could marry with parental consent, and anyone younger than 16 could marry if a judge approved. Now you have to be 18 to get married, but the law now allows in West Virginia for a person who is 16 or 17 to get permission from parents, or they have to petition the court and affirm they're entering into a marriage voluntarily. Unchained at Last says 33 states allow some form of child marriage.
Not legally, not developmentally, not in any framework that takes childhood seriously.
It is absolutely a forced marriage. Globally, any marriage in which even one party or both parties are under the age of 18 is recognized as forced marriage. It doesn't matter how mature or feisty or smart that minor might be. The fact is that you do not have the full rights of adulthood, all the legal rights, until age 18. And before you have the full rights of adulthood, I'm talking about basic rights like the right to leave home if your parent is planning an unwanted wedding for you, the right to get into a domestic violence shelter, retain an attorney, bring a legal action. Before you have these basic legal rights, you cannot say no to a marriage you don't want. You just cannot protect yourself from being forced to marry. That means you cannot give full, free consent to marriage. So by definition, that is a forced marriage. And forced marriage is a form of modern slavery. So we're talking about a really horrific situation. And it doesn't matter if a minor says yes, it's rape. Same thing with marriage. If you're too young to consent to marriage because you don't have the legal rights of adulthood, anytime someone is married before the age of 18, it is considered a forced marriage, and that is a form of modern slavery.
Let's reconstruct the timeline, because the gap between the wedding and the raid is where this case actually lives. March 2008. The marriage takes place in West Virginia. The bride is 15 and, according to reporting on the case, already 7 months pregnant at the time of the ceremony.
So I was forced in New York City to marry a stranger when I was 19, and he turned out to be violent, and I was trapped for 15 years in this abusive forced marriage. And when I finally managed to escape my family and community, I came from a very fundamentalist religious community. They retaliated by shunning me, and they consider me dead. It's been almost 20 years now. They still consider me dead. And so out of my traumatic experience, it took a long time for me to rebuild my life and move on. From my experience, I found it Unchained at Last. And at first, we were focused on direct services. I wanted to be there for other people who were escaping the same nightmare I had escaped, that their parents are forcing them to marry, not listening when they say no, or they're already in a marriage that they did not consent to. And escaping a forced marriage is difficult. So the services that we provide are crucial, comprehensive wraparound services. It's never easy for us to help somebody escape a forced.
May 2008. The couple's first daughter is born. Over the following 17 years, the family relocates repeatedly through some of the most economically strained counties in southeastern Ohio: Gallia, Jackson, Pike, and eventually Vinton. Each move appears to have functioned, whether intentionally or not, as a reset button. A 2021 truancy complaint was formally filed in Gallia County involving 6 of the older children in the household. Officials attempted to serve the family with that paperwork and could not locate them. The family had already relocated. The truancy case was dismissed for lack of service, and with it, the paper trail on those 6 children went cold. That's the detail investigators and lawmakers alike have zeroed in on. Not a single missed report. A pattern of the same family generating red flags. birth certificates from hospitals, a truancy filing, gaps in school enrollment, and having every single one of those flags fail to follow them to the next county line. Which brings us to the hard evidence, and to why this case has suddenly become bigger than one family's tragedy.
Elizabeth Siders was 15 years old in March of 2008. She was also, by that point, 7 months pregnant, and she could not legally marry in Ohio. The state's own law wouldn't allow it at her age. So she and Gary Siders Jr., who was 18, drove across the border into Mason County, West Virginia, where the law at the time allowed a 15-year-old to marry with parental consent. They were married on March 31, 2008. Their first daughter was born 2 months later. 17 more children followed over the years after that. Here's the detail that should stop you cold. This wasn't some obscure loophole nobody could have anticipated.
There is currently a bill sitting in the Ohio Senate, publicly filed, publicly numbered, co-sponsored across party lines, that would eliminate every remaining exception in Ohio's marriage law and simply set the minimum age at 18. No parental consent workaround. No judicial approval pathway around it. According to public legislative records, this bill cleared committee unanimously. Across 4 separate public hearings, no member of the public testified in opposition to it. And as of this recording, it still has not received a floor vote. Why does that matter to this specific case?
The bill that won't get a vote. Ohio isn't actually starting from scratch here. Senate Bill 341, introduced jointly by Republican Senator Lewis Blessing III and Democratic Senator Bill DeMora, would eliminate every exception currently in Ohio law and simply set the marriage age at 18. No parental consent workaround, no judicial approval pathway, just 18. The bill cleared the Senate Judiciary Committee unanimously. Across 4 separate public hearings, not one single member of the public testified against it. It has, according to reporting, the backing of Republican Senate leadership itself. And despite all of that, the Ohio Senate adjourned for summer recess without ever bringing it to a floor vote. Reese's reaction, in her own words, was blunt. It's just unbelievable that a bipartisan, common-sense bill that has no opposition from the public, that costs nothing, that harms no one except creepy men who prey on teenage girls. It is absolutely mind-boggling that a bill...
Because right now, in 2026, Ohio law still permits a 17-year-old to marry with a parent's signature and a court's approval. The exact mechanism that allowed a 15-year-old to legally marry in 2008. A state line, a signature, a system built on exceptions, has not been fully closed in the years since. It's simply been narrowed. National advocacy organizations that track this issue place Ohio's tally at more than 5,000 children married as minors since the year 2000. Nationally, estimates drawn from state vital records put that number near 300,000 minors married between 2000 and 2018 alone. 17 states, Washington, D.C., and 2 U.S. territories have closed this loophole entirely in the years since advocates began pushing state by state, starting around 2015. Ohio, as of this recording, is not one of them. Here's the ticking clock question worth sitting with for a second. How many more households like this one are currently operating, right now, in the gap between what the law technically permits and what basic human development actually allows?
Changes anything is direct. Under international human rights standards, any marriage where even one party is under 18 is considered a forced marriage, full stop, regardless of how mature, willing, or insistent that minor might seem. Her reasoning is precise. Before you turn 18, you don't have the legal rights that would let you actually refuse. You can't leave home without risking legal consequences yourself. You can't get into a domestic violence shelter. You can't retain your own attorney. Without those basic tools, Rice argues, you cannot give full, free consent, which makes the marriage forced by definition, whether or not the minor ever says the word no. She's drawn a direct comparison to statutory rape law. A child who says yes to sex before an age of legal consent is still, under the law, a victim of rape. The same principle, she argues, applies to marriage. That framing matters enormously for how you understand Elizabeth Siders' own story. Whatever she believed at 15, whatever her brother means by indoctrinated, the legal and human rights reality is that a 15-year-old cannot meaningfully consent to marrying an adult, regardless of pregnancy, regardless of family pressure. There's data behind this too. RIAE cites research showing 70 to 80% of marriages entered into before 18 end in divorce, a failure rate dramatically higher than adult marriages, and one she argues should reframe how anyone hearing, "but it worked out for someone I know," weighs that single anecdote against the broader pattern. Part 3.
There's a darker structural angle here too, one that rarely makes it into coverage of cases like this. Under current federal immigration policy, the U.S. government does not independently set a minimum marriage age for spousal or fiancé visa purposes. It defers entirely to whichever state's law applies. That means a state that still permits underage marriage isn't just a local family court issue. It's a federal-level vulnerability. A congressional oversight report examining human trafficking through marriage fraud has documented cases of teenagers, overwhelmingly girls, brought into the country under the legal cover of a marriage that a stricter state law would never have allowed to happen in the first place. Close the loophole at the state level, and that specific pathway closes with it. Let's return to the moral core, because it deserves repeating in a slightly different frame this time. A childhood spent pregnant is not a childhood at all, and no signature on a marriage license changes that fact. So where does the criminal case against this family actually stand right now? According to court filings, attorneys for 3 of the 4 defendants have raised questions about their client's competency to stand trial. A judge has approved formal competency evaluations to be conducted by a forensic examiner, with a set window for those evaluations to be completed. All 4 defendants remain charged with 16 counts, each of felony child endangering. All 4 remain out on the record as having pleaded not guilty. The investigation into exactly what occurred inside that house, and for how long, remains active and ongoing. We want to be precise here. Nothing in this case has been proven in a court of law. These are allegations, not convictions, and every person named in this case is legally presumed innocent unless and until a court finds otherwise. But separate from the criminal proceeding, there's a policy failure running underneath it that state lawmakers.
Senator Blessing has also raised a separate point about the Siders case specifically, one that isn't really about marriage law at all, and points instead at a much more basic institutional failure. His first reaction, he said, wasn't actually about the marriage. It was disbelief that a family with this many children could exist for years with essentially no paper trail. 16 children, born in hospitals, with real birth certificates. But somewhere after that, silence. No consistent school enrollment. No sustained government benefits. His suggestion is straightforward. Ohio's various state agencies, tax records, vital records, school enrollment systems, should already be capable of flagging exactly this kind of anomaly automatically, rather than requiring one overworked caseworker to notice it by hand. There's a real, documented example of exactly this kind of missed connection already sitting inside this case.
One state senator involved in sponsoring the marriage age bill has said on the record that his first reaction to this case wasn't actually about the marriage at all. It was disbelief that a family with 16 children could exist for years with almost no institutional paper trail connecting them across county lines. 16 birth certificates, generated in hospitals, each one a legitimate government record. And then, somewhere after that, silence. No consistent school enrollment data following the family. No sustained benefits paperwork. Each relocation effectively wiped the slate. His publicly stated proposal is for Ohio's separate state systems, vital records, tax filings, school enrollment, to be cross-referenced automatically, flagging exactly this kind of anomaly across county lines, rather than depending on a single overworked caseworker in a single county to happen to notice it by hand. It's worth naming the structural reality underneath that proposal, too. Child Protective Services in Ohio are funded and staffed primarily at the county level. The counties this family moved through, Gallia, Jackson, Pike, and finally Vinton, are consistently ranked among the most economically distressed in the state, often sharing regional caseworkers stretched across multiple counties simultaneously. That's not an excuse. It's context for how a red flag raised in one county in 2021 could simply vanish the moment a family crossed into the next one. Let's say the moral refrain one final time, because by now the pattern connecting the 2008 marriage to the 2026 discovery should be impossible to miss. A 15-year-old cannot consent to becoming a wife, and a system that lets her isn't protecting anyone. It's just making the harm easier to overlook. There's a wider comparison worth making before we close this file. This is not uniquely a rural Ohio failure, and it's not uniquely a backward state story either, whatever comment section shorthand might suggest. According to public statements from the bill's own sponsors, California, a state that markets itself as a leader on progressive family policy, currently has no statutory minimum age at all written into its marriage law. And even when a bill like Ohio's reaches a floor vote with overwhelming, bipartisan, publicly uncontested support, passage still isn't guaranteed. A nearly identical bill in Oklahoma cleared that state's Senate unanimously, then passed its House of Representatives by a single vote.
Then passed the House by a single vote. Part 4. The trafficking loophole nobody talks about. There's a darker dimension to this that goes beyond any individual family's story. The federal government does not set its own minimum marriage age for spousal or fiancé visas. It defers entirely to whatever the law happens to be in the state where the couple will live. Under Ohio's current law allowing marriage at 17, a 17-year-old girl in Ohio can, in principle, be legally used to sponsor an adult man from overseas for a visa and a path to citizenship. It runs the other direction, too. An adult man in Ohio can legally bring in a 17-year-old bride from another country, entirely under the legal cover of marriage.
This is a nationwide gap in the law, not a regional anomaly, and it exists almost everywhere in the country to one degree or another. So we're left with two threads running in parallel, and neither one has an ending yet. In the courtroom, a competency evaluation window is currently running, after which 4 adults will either be found fit to stand trial on 16 felony counts each, or the case will take a different path entirely. And in the Ohio State House, a bill with 0 recorded public opposition, unanimous committee support, and bipartisan sponsorship remains unvoted, waiting for the legislature to reconvene. If you want to look at the primary source material yourself rather than take our word for it, Ohio Senate Bill 341, the legislation eliminating marriage age exceptions in Ohio, is publicly available in full through the Ohio General Assembly's legislative website, including its committee hearing records and current status. It's worth 5 minutes of your time to see exactly what a bipartisan, 0 opposition bill actually looks like sitting untouched in a legislative calendar. And here's the question we'll leave open for the comments. When a bill costs the state nothing, harms no one who isn't already breaking the law, and can't find a single public objection across 4 hearings, what actually explains a legislature choosing not to vote on it? That's where we leave this case for now. A marriage license from 2008, a truancy complaint that vanished in 2021, and a bill still waiting for a vote in 2026, all 3 of them threads in the same rope.
Couldn't legally marry in her own state in 2008, so she crossed a county line into one where she could. Nearly 2 decades later, 16 of her children were found living in conditions investigators have struggled to fully put into words. And right now, a bill that would have closed that exact loophole sits in the Ohio Senate, fully supported, entirely uncontested by the public, and still, somehow without a vote. Senator Blessing has said he believes it eventually passes. Frady Reese and the survivors standing behind her aren't willing to simply wait and hope he's right. Whether this specific case finally becomes the reason Ohio lawmakers stop sitting on a bill this uncontroversial is something we'll be watching closely, right alongside the criminal case itself.
If this case affected you the way it affected us putting it together, hit like, share it with someone who needs to see how a paperwork gap can go unnoticed for almost 2 decades. Subscribe to the Hidden Case Files and turn on notifications, because we'll be following both the competency hearings and Senate Bill 341 as they move. This has been the Hidden Case Files. We'll see you